Hello, everyone. This is Tom Fox back for another episode. And today you're in for an uber treat because I have Karen Woody. Karen is associate professor at Washington and Lee in the School of Law. We are tangentially related because Karen's firm was the monitor of a company I was with when I was general counsel. So that makes us very close cousins, I think, Karen.
Right. I think that's right.
So, Karen, first of all, thank you so much for taking the time to visit with me today.
Oh, I'm so happy to be visiting with you, Tom. It's great to see you.
Karen, could you talk a little bit about your professional background and what led you to W&L?
Sure. It's a good question. Well, as you said, I practiced law in Washington, D.C. for about 10 years, doing white collar crime, corporate investigations, some securities fraud, a lot of internal deep dives into companies. And so we looked a lot at internal controls and compliance programs. And then I decided to pivot and I went into academia. So I was teaching, initially, I was teaching at Indiana University's Kelley School of Business, where I taught legal environment of business and a securities overview to business students. And then in 2019, I returned back home to Virginia, which is my home state, where I teach law at Washington Lee University. So still doing business law courses, but now to law students.
So, at least one of your specialties is around the Securities and Exchange Commission. I was just wondering what led you to either have that interest or that academic interest?
Well, it stems from my time in practice. I spent a number of hours over at the SEC negotiating settlements or advocating for various corporate clients and individual clients, actually, at the SEC, both in DC and New York. And so I had that background, and that is what sort of took me down the path of looking into a number of things that touch on the SEC's jurisdiction. So, of course, that includes disclosure obligations. One of my sort of niche areas was deals with conflict minerals, a disclosure obligation that came out of Dodd-Frank. And then, of course, FCPA and other sort of major matters that the SEC would be undertaking. Obviously, the FCPA is alongside with DOJ, but I often was focused on sort of the SEC angle, the accounting, books and records type violations. So any number of areas, I usually was dealing with someone over in that office.
So, Karen, I really wanted to visit with you about this chapter or this episode on internal controls. And I was wondering if we could just start with what is your definition of internal controls?
Well, it's a great question, and it is not necessarily entirely pinned down. It really is more of a qualitative principles type idea, but in sort of nuts and bolts or boiled down, internal controls are a system of policies and procedures that a corporation will enact that include things like various checks and balances, certain types of guardrails, if you will, in order to ensure that the company is compliant both with its own internal policies as well as obviously any federal or state statutory or any other sort of mandated regulations. And so this looks a lot like, what I often call them is the smoke alarm that hopefully goes off if there are any incidents of things that could be fraud, or even things that aren't necessarily intentional, sort of foot faults, even things that hopefully the company has some system in place to catch when there is some wrongdoing happening, even if that might be unintentional mistakes.
So, one of the things that's intrigued me about internal controls is there is, I think, at least some consistent body of internal controls that seem to be the basics that people agree every public or audited company should have. Yet, internal controls can change, they
Mm.
can evolve, they can grow as the bad guys get more sophisticated, as footballs become more prevalent. Would that be a fair analysis?
Yeah, and that's why it's hard to pin down a really tight definition because with all things it moves, and as people get even, if you're cynical about it, as people get maybe sort of more nefarious and can get around internal controls, that means you need to shift the controls to catch the loopholes that maybe some people can take advantage of.
One thing I think a lot of people don't understand about internal controls is they are not absolute. They
Right.
can be overridden by management override or an appropriate level of override, I should say. But there has to be some sort of justification, typically a business justification for that. Could you explain management override, kind of override of internal controls, but why that not is not necessarily an illegal act or perhaps even a bad thing?
Sure. I mean, you see this, and I teach this often even when I'm teaching general sort of corporate law and the role of the directors, and obviously the deference you give to directors. I mean, if we lived entirely in a risk-free world, then you might not have sidewalks because someone can trip. So there are times where we obviously want, certainly when you have a business you're running and you have the tension of needing to try to maximize profits, ensure that your business is viable, you might not be able to sort of, to use my analogy, rubberize every sidewalk. There are times where you will let certain things allow for additional risk, hoping that won't be problematic. And so I say that because, as you say, it's sort of a balancing act of weighing like the tension between ensuring that your business is able to be competitive and successful, while also, as I say, staying within the guardrails of both your policies and all sort of other regulations that apply to the business.
So, in evaluating or thinking about an override, what would you suggest be done to document why an override was either performed or granted?
Well, you use the most important word, which is to document it. That is always going to be critical to ensure that there's some understanding, some reason written down that management decided to either acknowledge that there might be some risk and still go ahead despite the risk. I do think, as we said, some of these are close calls, and they might very well turn on. Well, this is a business opportunity we need to take. We put these certain amount of controls in place, but obviously we can't ensure that we can, rake the sand in front of every person in this industry. So we might acknowledge there'll be some potential risk that we have allowed to go forward, knowing that means that's what we need in order to have our business keep going. But documenting it would be a huge step. And if it runs all the way up to higher level management, there is a decent amount of deference given to the board under a business judgment rule type idea, meaning that if it was ended up being somewhat of a tough call, there is some understanding that there was a reason that they made that decision. So the way to ensure that decision looks grounded in the best interest of the company is to document it and to ensure that they've laid it out. Another way to check is to, again, run it by a number of hopefully people that are in that room, like your chief compliance officer, your chief legal officer, or other sort of people that are ensuring that this is the wisest decision.
So, have you had either the opportunity or been required to back when you were practicing to literally sit across the table from an SEC representative and have a discussion with them about whether a control override was warranted or there was appropriate business justification? It's a long-winded way of saying, how does the SEC view overrides of internal controls, and what type of documentation may be acceptable in their eyes?
That's a great question. And unfortunately, I think my answer is if you're sitting in a room across the table from the SEC, they're probably not going to agree with the fact that the businessman or the management performed an override. It's funny because often when I was dealing with this, I was coming from almost a different lens or a different way to look at that, which is, if anything, the SEC was annoyed that there wasn't some internal control that would have tipped off or would have stopped some sort of behavior. So it wasn't, I'm trying to remember incidents where they said, oh yeah, management knew about this and looked away. It was much more that something went wrong. We had some rogue employee or someone, and we didn't have a system to have caught that before it happened. So I'm trying to think if there were, close calls where management would have said, yeah, we kind of knew that might have happened, but we ignored it. The SEC is not going to take kindly to that argument.
Karen, in the summer of 2014, I read this document entitled the COSO 2013 Internal Controls Frameworks. And it was one of the biggest revelations I've had since I've been in compliance. And I literally said, who wrote this? This is incredible. This is a compliance internal control program. Who's calling this financial controls? Who's doing this? And when I talked to someone who had any knowledge of internal controls, they did what you just did. They smirked, and they sometimes they roll their eyes. But then I would say, "But look, I'm a lawyer. You don't understand. I always thought these were lawyers do cool things. They don't do controls." And it really was a revelation to me. And it was a
Hmm.
revelation because the framework itself is broad enough to cover a variety of disciplines: safety, health, compliance, financials. But it also laid it out in a way that I thought set a backbone for a best practices compliance program. So I wondered if you just might give some general thoughts, your thoughts on the COSO 2013 framework, how powerful you thought it may have been, the kind of
Mhm.
work that went into it, and then we can talk about some of the individual objectives and how a compliance practitioner can use it.
It's a great question, and you're right. It is such a powerful tool that the committee of sponsoring organizations, or COSO, as you said, pulled together, and it's really was sort of thought leadership on how to have a robust compliance program. And it is, as we'll talk about here in a minute, very principles based, meaning that it's not sort of check the box on everything. We're going to have a broad idea, knowing that there will be a lot of potential iterations or versions of compliance programs that meet those principles. And so I think it is obviously very widespread in terms of all the types of principles, but it's also one that I think is putting very much intuitive and common sense type structure on what most compliance officers hopefully have already set in motion or are thinking about. But this way does lay it out in a very clear structure. So it's easy for people to follow along, and walks through, very clear objectives. And then with those objectives has principles under them to ensure that you're sort of not missing anything. I think the weight of different certain areas of those might be given different be given different, well, weight, I guess I would say, between those different objectives. There obviously are some maybe more hot button areas of compliance programs, or I would say maybe more risk laden areas that compliance programs need to ensure that they have. And that might just also depend on industry and area of the world in which the company is operating. So it is very comprehensive, very complex in some ways, but I think it hits every sort of potential uh, area in which you could find a potential compliance problem. So yeah, so I think this is a huge document. It's a really important resource for anyone who's in this field.
Do you think that lawyers have finally gotten it about internal controls, or do you still sort of hear that same, "Look, I'm a lawyer. I do cool things. I do
Yeah,
investigations. I
I don't
talk to the
do.
government.
Yeah,
I don't do controls." Those people down the hall who we don't let out um,
right.
do the controls. Is that sort of mentality still around?
Not as much. There was a little bit of this, what we would call JD preferred is who the compliance people are. Like you're not even might not even be a lawyer, but you're close enough. There's a little of that sort of vibe still, but honestly, everyone who's doing the internal investigations, the remediation and what you need to show after having done the investigation is a robust compliance program. And that's what you walk into the government and show, to say, listen, we have cleaned house, we've fixed some of these problems. Here is how airtight our compliance program is going forward. And so it's sort of two sides of the same coin. And so it'd be hard to divorce those things at this point. And so I think almost every lawyer knows that. Certainly everyone who's representing a company that has been anywhere near the FCPA, or has even just reads the Wall Street Journal and sees the numbers of the fines that come in just on lack of internal controls alone. It's not something people can ignore.
So I was wondering if we could go through the five objectives and you could just sort of describe generally what they are and how you see them utilized. And if we could start with objective one, control environment.
Right. So that's exactly what it says, which is the environment. I think is sort of the operative word there, and that is sort of tone at the top, which is a phrase you hear all of the time in the compliance programs. This talks about this idea of, it's hard to put again in like quantitative terms because it does deal with that idea of environment. How do you describe that? So, I would use words like character, ethical, commitment on behalf of management and senior officers. This does sort of deal with this broad structure of the company in order to have an environment that stands up robust controls. So there's that. So this is commitment, again, to this idea of ethics and integrity. That's actually even the first principle under this one. But then also under this objective is some ways to affect that. So talking through, this idea of what the delegation of authority type idea is, who's overseeing what is the structure of the compliance arm of the company, who the dotted line reports are, who are the, all these ideas of how do we ensure that the right people are seeing the information and are overseeing, who's making important decisions. So under this first objective, like I said, you have this, again, commitment to an ethical company, but then also talk through how do we do that. We have the board having some oversight. We have a very clear compliance structure. We're clear about who has what level of authority. Also under this objective is the idea of ensuring that you have training, sort of employees are able to be trained on these things, that you are ensuring that you are hiring good individuals who share this same level of ethical commitment, and that there are potential ramifications for failing to have this level of commitment, that there's something in place that shows, there is sort of a carrot and stick idea here, that there could be a stick if you fail to meet the policies that the company puts in place.
Karen, I'm glad you expanded on the structure of the COSO framework, because I started off with the objectives. You said, well, there are 5 principles under this, and then you didn't name them. But here's the next step that for me was the real power, which is their points of focus. And those points of focus give you specific actions
Mm-hmm.
that you could engage in or put in your compliance program to test whether or not the internal controls were working. And there's having done this exercise, there's 5 objectives, 17 principles, and 84 points of focus because I mapped the 10 hallmarks in an effective compliance program to that once. And it really does give you some specific things, like we all hear tone at the top. And for years it was, well, how do we measure it? Well, the COSO framework tells you how. And they give
Sure.
you a principle, and then they give you multiple points of focus that you can point your leaders towards to say, this is how we're going to show it. So
Mm-hmm.
that to me was really the power of it. It was more than just logical or intuitive and principle based. And it really went down into some very specific weeds of, this is how we suggest you do it. Doesn't mean we're the best, and if you can improve on it, certainly do it. But it gave you a framework to think about all of this.
Right.
So
And I
what
think
about
that rings true for even these other objectives. I think we'll talk through that. There is an overarching idea, but they really do, like you say, drill down on how to meet those goals.
how about risk assessments? What did you see in that objective?
What I like about how they wrote this part is this idea that it's easy to point to risk. It's easy to think through, oh man, we're doing business in this country that's on Transparency International's list of most corrupt countries or something like that. But this one is an interesting one in that they talk through, okay, we can identify the risk, but how do we assess it? Like, how do we have these objectives of how we want to meet the goals of managing that risk? So it's not just identifying risk. There's sort of that next step of thinking through, what's our objective given that risk? How do we analyze it and get through, sort of sail through maybe some rocky waters in some ways, or choppy waters, I guess is the better metaphor there. And then also they also talk about this idea of, fraud risk is one of them too, which I don't know if I necessarily would separate that out as its own category, but certainly looking at this idea of what about sort of bad actors, people who aren't just having mistakes or unaware, but are intentionally, taking on we're risking that people are going to be acting fraudulently. That falls under this risk assessment paradigm. And then also this idea that, there will be things that will shift, and sort of this idea that this can be a dynamic idea here. That's one of the principles under this idea of analyzing change, identifying where things change and shift, and that, you can have, a business that can react to that, and include that change in the risk framework and assessment.
So how about the next objective, control activities?
Okay, control activities. So this one I think is an interesting one, because it is about this, and I think very critical for internal controls, absolutely. So here you have this idea of what are the tools we are doing to stand up these controls. So this section talks a lot about who is assigned to monitor these things, sort of this who has what authority and what duties in preventing and detecting fraud or any other activity that would trigger an internal control. And so this also includes technology, the use of monitoring via technology, and sort of how to ensure that there are programs in place to catch these things. And then, I think this really is this idea of trying to, really do the stress tests of a company, really running the traps of whether these internal controls would catch a variety of different types of activities. You tell me, Tom, if I'm speaking out of turn, if you think I'm off on some of my descriptions of these, because I know you've wrestled with these for a long time. But that's sort of how I see that principle or this objective.
No, and that's part of the beauty, I think, of the coastal framework is it has the flexibility that you and I can have different interpretations, or there can be multiple interpretations, and they all could be right. Because for me, it's all about your documentation. That if you have a control, that you have a guardrail, you have a smoke detector, and you document that you have gone up and tested under that smoke detector and no smokes come out, or if smokes come out, you've documented the reason you've moved forward. That's the purpose of the control.
Mm-hmm. Mm-hmm.
So number 4 is information and communication. And these next two were revelatory to me, and really for a different reason. In the information and communication, I was stunned when I read it, because it talked about not simply corporate communication from the top down. It talked about corporate communication from the bottom up, but
Right.
it also talked about external stakeholder communication back to the corporation, and corporation communications with stakeholders, particularly third parties who might be sales agents, distributors, or others. And that was not really something in 2012 or 2010 that I think a lot of compliance practitioners were focused on, that outbound nature of communication, other than perhaps an hour a year in anti-bribery training. So
That's exactly right. I had that same thought when I was reading through Skin. Like, this was sort of new. I mean,
Right.
we all were talking about the hotline and, whistleblower sort of avenues, and, the idea that we want to keep that as internal as possible, at least in the first instance. And then obviously after Dodd-Frank, that became a little trickier when there were such, bounties for whistleblowers. But this idea of sort of open communication, I think it, as all of these, they sort of integrate and weave back to the bigger themes here, which really is this idea that we are committed to having an ethical company. One way to do that is to ensure that there is open communication and some transparency. And as you said, going both directions, from top down and then from bottom up, sort of both ways. And then outside of the company, that was the one that, as you said, sort of this external communication to other stakeholders, and recognizing that that's an important feature, I think was a really important addition that COSO put in here, that I don't know that compliance officers were thinking about maybe until I had seen this.
And then objective 5 is monitoring activities. And I found that my reaction to that was a little similar, because I certainly knew what monitoring was, even if I didn't really advocate it, because once again, that's what control people do, and that's not cool lawyer stuff. But the part that was revelatory for me was, it's not simply monitoring, it's taking the information that you
Yeah.
gain from the monitoring and incorporating it back into your system. If it needs remediation, you remediate, but you can also use it for improvement. This is almost 8 or 9 years before the Department of Justice said you need continuous monitoring and you need continuous improvement. So, uh, what were your thoughts on this objective?
Similar to yours, which is, you know, this seemed sort of novel. It seemed like it was a first mover of having such a wide, broad idea of what compliance and monitoring means. And you're right, that beat even the government from explaining what they're looking for. This laid out like you should already have that type of idea of sort of this iterative sort of feedback loop already in place for your compliance program that I think is huge because that's usually what's happening. As I said, at the beginning of this, that there are ways that people learn how to circumvent these internal controls. So it does need to be a dynamic policy, and this is an objective that makes that very clear. Like we have to sort of be continually improving upon these to ensure that we're doing what we're asked to do as compliance professionals.
Karen, there was one other area that I've actually wanted to talk to you about for a long time, and that is when the SEC brings an enforcement action where there's no evidence of bribery, at least in the cease and desist order, but there's an internal control violation found. Some people call that a non-bribery FCPA enforcement action. I call it an internal controls enforcement action. But what does really the SEC view its role with regard to public companies and the internal control provision found in the accounting provisions of the FCPA?
This is a very dynamic area of the law. I think I wrote an article about this about 5 years ago, and it was actually the title of it was "No Smoke and No Fire." It was this idea that we don't have bribery, we might not even have an actual accounting discrepancy, but they still said if you had one of those, your internal controls wouldn't have caught it. And I was arguing that that's over prosecution to say the least. Sort of like, well, nothing has happened yet, but this idea of like you can still be dinged just because you wouldn't catch it if it does happen, and that I was wrong in the sense that the SEC does not take that same view. They have very much used the internal controls provision to come after companies with obviously without an anti-bribery maybe foundation, but now even in areas of the law that don't deal with the FCPA or bribery at all. So they're using this Section 13 B2B on requiring internal controls writ large. So we just saw a case last fall out of Texas, actually, so the Andover case, which dealt with a company doing stock buybacks under their 10b5-1 plan. And so an insider trading issue is basically the substance of the violation. But the SEC didn't bring an insider trading claim. They actually said, well, we're going to bring an internal controls violation because you didn't comply with your internal policies that you would be sure that the stock buybacks aren't violating a potential insider trading, or even not federal insider trading, but your own policies of the company. And so that was sort of a novel idea of like, wait, we can just now pick this provision up and apply it in a number of different areas. And you also talked about the United case, wherein again we had a domestic potential bribery situation, so couldn't be prosecuted under the FCPA, but still using that internal controls provision as applicable to the activity that was occurring in that case as well a few years ago. So I think the SEC is able to really stretch this provision and use it widely, and I think we'll see a lot more of that.
The Department of Justice, separate apart from the SEC, has for the last year or so started talking much more aggressively about effective compliance programs. And it's led me and others to speculate, are they going to now start testing the effectiveness of a compliance program? I don't think they can do that in a criminal setting because you don't have a bribe. But if the DOJ starts testing the effectiveness of compliance programs, I think that could open up really another avenue for the government to look at controls, test controls. And even if you haven't had a bribe and there's no fire and there's no smoke, but if your program itself is not effective, it could potentially lead to some action by the government.
Yeah, I mean, what is interesting is that, like, query how they even come up with that unless there is something that went wrong. I mean, it's sort of, as I say, like it's an interesting way that these cases even come up, because you can almost pick up anything and say, I'm going to stress test this. Would it have caught something? And so sometimes we saw these because they didn't think they had enough to make the case on the other ones. But you're right. We could get to a place where they just, call you up and do these hypotheticals really to a company and to see that their internal controls would catch one thing or the other. And so, yeah, I think we could see that being additional risk for companies, or that's coming at them, at least certainly from the government side.
Well, Karen, unfortunately, we now are at the end of our time, but this has just been way too much fun. I hope I can call upon you maybe down the road
Of course.
to come back on. So I wanted to thank you again.
Awesome. Thank you so much, Tom. This has been great.